Committee on Oversight and Government Reform will come to order. Pursuant to Committee Rules 5B and House Rule 11-2H4, the Chair announces that he may postpone further proceedings today on any question of approving any measure or matter on which a recorded vote or the yeas and nays are ordered. And without objection, the Chair is authorized to declare a recess at any time. Today's business meeting has only one piece of legislation up for consideration, but it's an important one. The D.C. Council passed legislation that affects the hiring and retention practices of all district employees, including politically and religiously affiliated organizations. Specifically, the bill forces employers to hire and retain individuals whose beliefs regarding reproductive health decisions are different from the beliefs advocated by the employer. Organizations most affected are those that exist solely to advance these beliefs. As passed, the bill fails to recognize certain long-standing constitutional protections. Because of this, we cannot let this legislation stand. Former Washington, D.C. Mayor Vincent Gray clearly understood the legal concerns of this bill and requested that the Council postpone its vote on the bill. In a December 2014 letter to the D.C. Council Chairman Mendelson, Mayor Gray explained that the D.C.'s Attorney General found the bill, quote, raised serious concerns under the Constitution and under the Religious Freedom Restoration Act of 1993, end quote. Mayor Gray went on to say, quote, religious organizations, religiously affiliated organizations, religiously driven for-profit entities, and political organizations may have strong First Amendment and Religious Freedom Restoration Act grounds for challenging the law's application to them, end quote. This is from the mayor of Washington, D.C. at the time. As a solution, the mayor requested that the Council include a simple exemption to, quote, protect the religious and political liberty interests that the First Amendment and the Religious Freedom Restoration Act are designed to secure, end quote. We happen to agree with that. But instead, the Council, under newly elected Mayor Bowser, chose to ignore the former mayor's remedy, passed the bill as is, and sent it to Congress. If they had taken Mayor Gray's advice, we would not be sitting here today. I'd like to ask unanimous consent to enter into the record the letter from Mayor Gray dated December 2nd, 2014. Hearing no objections, so ordered. The law is contrary to Federal statute, and both Mayor Bowser and the D.C. Council know it. The Religious Freedom Restoration Act, passed in 1993, prevents the government from creating any law, rule, or regulation that prevents an individual from freely exercising their religion. Based on this mandate, the Supreme Court recently held that certain corporations are not required to provide health insurance coverage for contraceptive methods that violates religious beliefs. From the way it was drafted, it is unclear if the D.C. bill violates this mandate, and both Mayor Bowser and the D.C. Council know this is a problem. In February, Mayor Bowser admitted the bill was ambiguous and requested the Council pass temporary emergency legislation clarifying the bill doesn't require employers to provide insurance coverage for reproductive health decisions. I'd like to ask unanimous consent to enter into the record a letter from Mayor Bowser dated February 2nd, 2015. Hearing no objections, so ordered. The Council passed the Mayor's requested fix. But that fix is only temporary and does not address the constitutional concerns I share with Mayor Gray. I appreciate the Council's efforts to work with my staff, but until a permanent fix is created, the bill remains dangerously ambiguous. Given such ambiguity, and without a permanent fix, the bill cannot stand given the recent Supreme Court decision in the Hobby Lobby case. In other words, the bill Washington, D.C. sent to the United States Congress is not a bill that they even support. Mayor Gray doesn't support it. Mayor Bowser cited the problems with it. The D.C. District Attorney General said that there was a problem with it. But they haven't sent this fix to Congress. That has not arrived. Now, I did receive a letter today from the D.C. Council, but it still doesn't fix the problem. We have to deal with the exact piece of legislation that was presented to Congress. And both Mayor Gray and Mayor Bowser, the D.C. Council, and the Attorney General for Washington, D.C. all recognize that it's problematic. And so as emotionally charged and and convinced that this is the right type of bill that should pass. We have to deal with the legality of what is exactly before us today. I truly enjoy working with Mr. Cummings, the ranking member of this committee, and I understand that we are on different sides of this issue. I know that members on both sides of the dais will have strong feelings to express today. And I know that we're going to have a vigorous debate and look forward to that. That's what we should be doing in Congress. But let's be careful not to engage in hyperbole that misrepresents legitimate concerns and rhetoric that serves only to score political points and produce snappy sound bites without bringing us any closer to a resolution. So I would urge the passage of this resolution here today and look forward to this discussion. And now recognize the ranking member, Mr. Cummings, for 5 minutes.
Thank you very much, Mr. Chairman. And I know personally the importance of faith in the lives of Americans across our great country. As the son of 2 Pentecostal ministers from a small church in Baltimore, I know firsthand how fundamental values can inspire communities to come together, worship, and help their neighbors improve their lives. In addition, as a lawyer and a member of Congress, I understand that we have an obligation to make accommodations when appropriate to avoid undue influence with the practice of religion. However, I strongly oppose the resolution before us today because it infringes on the reproductive rights of American citizens, allows employers to discriminate against employees based on their personal health decisions, and tramples on the rights of the people of the District of Columbia to simply govern themselves. In January, the mayor of the District of Columbia signed the Reproductive Health Non-Discrimination Amendment Act, which was passed by the district's elected representatives on the D.C. Council. The Act prohibits employers from discriminating against employees based upon their reproductive health decisions. It also protects the reproductive health decisions of their spouses and their dependents. Under federal law, a district law may be overturned if both houses of Congress vote to do so, and the President agrees within 30 legislative days. But this process, known as a resolution of disapproval, has not been used for decades, that is, until today. Apparently, the Republicans in Congress find the district's law protecting women's reproductive health decisions so shocking and so repugnant that they are resurrecting this virtually dormant tactic in an attempt to reverse it. I have several fundamental concerns with this action. First, congressional Republicans are impinging on the rights of women in the District of Columbia to make their own reproductive health decisions without fear that their bosses will punish them as a result. For example, under this resolution, Republicans would permit employers to fire a woman because she has an abortion after being raped. I cannot imagine the trauma a woman in this terrible situation must suffer, but it would only be aggravated by losing her job after the fact. Under this resolution, the Republicans would allow employers to take other types of discriminatory actions. For example, Republicans would allow an employer to demote a woman or pay her less if she chooses to take birth control pills. This resolution would not affect only the rights of women. Republicans would allow an employer to fire a male worker because he uses condoms, because his wife uses a pill, or because his teenage daughter becomes pregnant out of wedlock. Something is wrong with that picture. So for those men who think this resolution does not affect them, think again. It affects everyone. This issue is clearly a priority for the Republican leadership. Our committee would not be resuscitating a decades-old process to overturn this law unless the Speaker and the Republican leadership were pushing it. But this is the same committee that brought the world Sandra Fluke. She wanted to come here, remember, to this very witness table and testify about contraceptives on February 16, 2012. But our former chairman refused to let her speak. He said simply she was not qualified. And then Rush Limbaugh joined in, cruelly disparaging her merely for wanting to express her opinion. Mr. Chairman, isn't that exactly what this committee is doing today to the people of the District of Columbia? They have spoken. They simply want their voice in their own government, and they want to rule themselves. They express their will, and their elected officials pass a law protecting their rights. But now this committee, the same committee that tried to silence Sandra Fluke, is trying to silence the voters of the District of Columbia. Far be it from me to give Republicans political advice, but this approach will backfire this time, just as it did with Sandra Fluke. She ultimately persevered. She gave a voice to millions of women across the country, and she was heard far and wide. And so with that, Mr. Chairman, I strongly urge all of my colleagues to vote against this measure, and I yield back.
Thank the gentleman. Now I'll call up HJ Resolution 43, and without objection, the first reading is dispensed with. The clerk shall report the title of the legislation.
HJ Res 43, disapproving the action of the District of Columbia Council in approving the Reproductive Health Non-Discrimination Amendment Act of 2014.
Thank you. I'd like to take a moment to discuss the procedure under which we will be considering the resolution this evening. It is my intent to give every member ample opportunity to discuss the resolution under the 5-minute rule, the same way we discuss every other measure that comes before the committee. In terms of amendments, however, the expedited procedures for the Home Rule Act provide that the joint resolution is unamendable on the floor. The Office of the Parliamentarian has advised us that this unamendability extends to the committee. Accordingly, amendments to the joint resolution will not be entertained. At this point, it would be appropriate to recognize members who wish to speak on the resolution that's before us today. We'll start with the gentleman from the district, the delegate, Ms. Norton.
Thank you very much, Mr. Chairman, and I appreciate the conversations I've had with the majority and any and for that matter, any conversations you may have had with the district. On the other hand, I can see why the majority has scheduled this markup at the unusual hour of 5 p.m. There is no pride to be taken in what the committee is doing today. I should not have to state the obvious. The District of Columbia was granted authority to govern itself in the Home Rule Act of 1973, and I'm the only member of this committee elected by and accountable to the residents of the District of Columbia. I will vote in committee today, but if this bill goes to the floor, I will not be able to vote on it, but every member of this committee and of Congress will be. A member from Tennessee, Diane Black, who is not even on this committee, introduced this resolution to disapprove a lawful and constitutional law of a jurisdiction that has no way to hold her accountable. What a free ride that is. Similarly, a chairman from Utah is using the outsized weight of federal jurisdiction to overturn a local law in contradiction to Federalist local control principles that otherwise are the mantra of the majority. The D.C. law being questioned was transmitted to Congress on March 6th in time for a hearing. Yet the District of Columbia mayor and council chair have been denied even the opportunity to defend their own bill. This markup makes no pretense at fairness. The reason for Republican action today boils down to their political disagreement with the district's local law, their willingness to override their own local control principles, and above all, their subservience to the interest groups that are the prime movers for today's markup. My Republican colleagues will cite freedom of religion, which in this case would mean the freedom of any employer in the District of Columbia to discriminate against any employee because of the personal, constitutionally protected reproductive choices she makes in her private capacity, even though she is ready and willing to carry out her employer's policies and practices on the job, whatever they may be. This is not freedom of religion. It is the freedom to discriminate. Fortunately, our federal courts have allowed employers to use their personal, have never allowed employers to use their personal religious objections to hiring or firing employees, or there would be nothing whatsoever left of the nation's anti-discrimination laws. Under numerous Supreme Court decisions, the D.C. law complies with the First Amendment because it is a neutral bill of general applicability. That is a bill that does not target religion. As the Supreme Court held in Employment Division, Oregon Department of Human Resources versus Smith, the Free Exercise Clause never, quote, relieves an individual of the obligation to comply with a valid and neutral law of general applicability. The D.C. law also complies with the Religious Freedom Restoration Act, which provides a higher standard of review than the First Amendment. Under that act, a law must serve a compelling governmental interest in the least restrictive means possible. The D.C. law serves the compelling governmental interest of protecting women and men from workplace discrimination, and the courts have held that non-discrimination measures are the least restrictive means to eradicate discrimination. However, if this resolution is enacted into law, employers will be able to impose their religious preferences by discriminating against employees for a multitude of reasons. For example, for having an abortion due to rape or incest, or becoming pregnant while unmarried. The need for a religious exception has been cited. The D.C. law is subject to the so-called constitutional ministerial exception for religious organizations to employment discrimination laws, to a federal statutory exception for
Gentlewoman's time has expired, but ask unanimous consent to give the woman additional 1 minute.
I thank the gentleman. Exception for religious organizations under federal employment discrimination law, and to a statutory exception for religious and political organizations under D.C.'s employment discrimination law. However, in another Supreme Court hearing, the court held that the First Amendment provides a ministerial exemption for religious organizations to employment discrimination laws. The exception permits a religious organization to hire or fire a minister or ministerial employee for any reason whatsoever. The district's employment discrimination law, the Human Rights Act, also contains a statutory exception for religious and political organization that is patterned after Title VII of the Civil Rights Act of 1964, which I administered as chair of the Equal Employment Opportunity Commission, that grant religious organizations the ability to consider religion in employment decisions. Such an exemption allows the religious organization to hire individuals who share the same religion as the employer. The statutory exception in D.C.'s human rights law.
The gentlewoman's time has expired. Ask unanimous consent to give the gentlewoman additional 2 minutes.
I appreciate the gentleman's indulgence.
So ordered.
The D.C. exemption says that nothing in the Act shall prohibit religious and political organizations from limiting employment or admission or to giving preference to persons of the same religion or same political persuasion, as is calculated by the organization to promote the religious or political principles for which it is established or maintained. However, the federal courts have been vigilant to contain religious objection because our Constitution, must accommodate other rights simultaneously, including the right to be free from discrimination and the right to privacy. There is already an exception for interest groups based on their belief or religion. What the majority wants is an exception to hire or fire based on private conduct and personal conduct, off the job at that. In America, there has been growing angst about the loss of privacy following the NSA controversy. I wager that the only intrusion Americans fear today, almost as much as government intrusion, would be life or death control over one's livelihood based on private reproductive conduct. Until today's resolution, most thought that at least that private reproductive health decisions were for them alone. D.C. is not alone in our fight to protect home rule, workplace equality, and an employee's private reproductive decisions. I ask unanimous consent to place into the record a letter from 20 religious and interfaith groups opposing this resolution, a letter signed by 50 national and local groups calling on Congress to reject this disapproval resolution, and a letter from Philip Mendelson, the chairman of the council, which passed the law before us today.
Without objection, so ordered. Gentlewoman's time has expired. Does any other member wish to speak on the resolution before us today? Gentleman from Virginia, Mr. Conley, is recognized for 5 minutes.
Thank you, Mr. Chairman. Today, apparently, in what is actually a fairly extraordinary act, we are going to overturn a decision made by a local government because we can. Not because we should, but because we can. If we really believe in the principle of self-governance, if we really want the devolution of as much power as can be devolved to local and state governments, today's predictable action really belies it. Is there any possibility we could stop and think? This decision today isn't about our moral judgment about somebody else's legislation. It's about the right to self-governance. It's about the right of the District of Columbia and its residents to determine their own fate, whether we like it or not, whether we concur or not. What member on either side of the aisle would welcome congressional intrusion in the jurisdiction and the governing acts of your local governing body? None of us. None of us would welcome that. And although the Constitution certainly vests Congress with oversight powers of the district, we should use it sparingly, and we should use it when it affects national interests, not an ideological agenda, not a partisan agenda, and certainly not an intrusion simply because we can. The action we're about to take, in my opinion, is misguided. And if I were to talk about the substance of it, I would say that in the name of preventing bigotry, we're about to enshrine it. We're very divided on this subject. The country is divided on the subject. And the majority at the moment has the votes to prevail. And they're going to use those votes. That's why we have an extraordinary 5 o'clock markup. The last time we did this, I believe Dan Burton was in your chair, Mr. Chairman. And we were shooting at watermelons, and we were subpoenaing anything that walked, and we were engaged in conspiracy theories that brought discredit, frankly, upon this committee and its deliberations. You have consciously chosen to avoid that kind of histrionic. But I am disappointed that we have put this item on our agenda. I do not believe it belongs there. I associate myself with the remarks of our colleague and a friend from the District of Columbia, and I wish we would reconsider. I know that's a hopeless thought, but I wanted to register my strong disapproval about the action we're about to take. Thank you. With that, I yield back.
Thank the gentleman. Does any other member wish to be heard? Committee will come to order. Committee will come to order. Chairman is responsible under the rules of the House and the rules of the committee to maintain order and preserve decorum in the committee. Does any member wish to be heard on the gentlewoman from New York, Ms. Maloney, is recognized for 5 minutes.
Mr. Chairman, today's markup it doesn't just trample on the rights of the people of Washington, D.C. to govern themselves. It also makes a mockery of the majority party's oft-repeated claims that it wishes to scale back what it calls the overreach of the federal government. And let's be crystal clear. This bill is an insult to women everywhere. What business is it of an employer, or anyone else for that matter, to know whether or not workers or their daughters are taking birth control? It is none of their business. But this offensive effort to intrude into the most intimate of decisions of a woman's life sends a loud and clear message from the majority on this committee that you think a woman's employer does get a say in a woman's reproductive health care choices, even though the Supreme Court, the Constitution, and women all across this country think that it does not. This resolution would give an employer coercive power to intrude on a woman's private decisions about birth control, in vitro fertilization, and abortion. These are activities that are none of the employer's business. They are activities that obviously happen off the job and decisions that have no bearing whatsoever in any way on a woman's ability to do her job. Nor should her family members be held liable by their own employer for her health care choices. And the law this resolution would overturn only does what our government was instituted to do. It mediates fairly between two opposing claims of rights and freedoms. The District of Columbia's Reproductive Health Non-Discrimination Amendment Act does not diminish the right of religious freedom. The D.C. bill simply protects a woman's right to self-determination. It handles a perceived conflict between two differing claims to rights in a simple and straightforward way. An employer has the right to hold whatever belief his conscience dictates, but he does not have the right to discriminate against employees based on their private choices to use birth control. The D.C. law received a unanimous vote on the D.C. Council and was even revised to make it clear that it would not force an employer to provide insurance coverage for contraceptive or abortion coverage. This new D.C. law is modest in its scope, which makes the action by this committee all the more shocking. This resolution threatens the livelihoods and economic security of hard-working men and women in D.C., and while this resolution might just affect women and their families here in our nation's capital, women across the United States should be alarmed. Because if this resolution stands, can there be any doubt that they might be coming after them next? I offer my support for D.C.'s Reproductive Health Non-Discrimination Amendment Act and urge my colleagues to oppose this absurd, discriminatory resolution. I yield back.
Thank the gentlewoman. We'll pause here for a moment. Does any other member wish to be heard on this amendment? In just a moment, we will recognize you. Members will be advised that it is our intention to go until 6:30. 6:30 p.m. We do have a vote on the floor, so we will continue to do this until 6:30. Thank you. We appreciate the Capitol Police and everything they do for us. We'll now recognize the gentleman from Oklahoma, Mr. Russell, for 5 minutes.
Thank you, Mr. Chairman. Religious freedom is not bigotry. Silencing it is. Article 1, Section 8 of the Constitution is pretty clear when it states that Congress has the authority to exercise, quote, exclusive legislation in all cases whatsoever, unquote, pertaining to the District of Columbia. While Congress granted the city limited home rule authority in 1973, the fact remains that Congress retains the authority to review and approve all district laws, and it is no secret historically that the district has a history of blatantly ignoring congressional intent that affects the entire country. For example, the District of Columbia even broke the law and funded abortions in 1997 and 98 until it was uncovered, reported in the press, and stopped. It's also mindful to note in what is viewed as a local action is actually something with national implication. In 2012, the Supreme Court unanimously affirmed the right of religious organizations to hire individuals that support the mission of the organization where the individual is responsible for carrying out that. In their decision, Hosanna Tabor versus the EEOC, it states, the interest of society in the enforcement and employment discrimination statutes is undoubtedly important. But so too is the interest of religious groups in choosing who will preach their beliefs, teach their faith, and carry out their mission. When a minister who has been fired sues her church alleging that her termination was discriminatory, the First Amendment has struck the balance for us. The church must be free to choose those who will guide its way, unquote. This from the Supreme Court in a recent decision. There are some progressives, most all, are against murder. So are some and most all conservatives. The difference lies in that conservatives and many others who hold strong religious conviction that God creates life and it begins at conception, and consequently view killing unborn children as murder. It's not that a progressive or a conservative oppose murder, it's the difference that when we think a murder occurs. And violating that view in the forceful implementation of a D.C. law passed in some council by one or two individuals, it is the right of Congress constitutionally in Article 1, Section 8, to hold these things in oversight and in trust for the American people. I, for one, not only stand for protecting life, but I also have defended nearly losing my own life in armed service combat around the globe in defense of the Bill of Rights of the Constitution of the United States. And so today, with my colleagues who I hold in high esteem and have great respect for, it's important to note that we may be called many names and we may have a view pushed upon us that makes us look draconian, but the fact of the matter is the First Amendment protects our religious liberty, and it is something that we should all be willing to die for. And with that, Mr. Chairman, I yield back.
Thank the gentleman. Now recognize the gentleman from Massachusetts, Mr. Lynch, for 5 minutes.
Thank you, Mr. Chairman. And I appreciate the amount of time that you have afforded our representative here in District of Columbia in order to express her views. I'd like to express my strong opposition to the House resolution 43, introduced by Ms. Black of Tennessee last week. This resolution would disapprove of the Washington, D.C. City Council's unanimous adoption of the Reproductive Health Non-Discrimination Act of 2014. This local act addresses employment discrimination. It is an employment protection ordinance, plain and simple. And it was signed into law by, it was passed unanimously by the D.C. City Council and signed by Mayor Muriel Bowser in January of 2015. Now, in light of the diversity of opinion on this committee, it's not surprising that members hold different views of the merits of the D.C. City Council vote on this issue. However, I'm fairly certain that we all share a genuine commitment to upholding the core democratic principle of local self-governance as we represent the geographically and demographically distinct areas that make up our various congressional districts across the country. It is the collective and sworn duty as federal lawmakers to safeguard local government autonomy and the basic right of our citizens to make decisions regarding their local affairs. That must guide our determination on whether to go so far as to invoke the congressional disapproval process set forth in the D.C. Home Rule Act of '73. As noted by President Lyndon Johnson in his 1965 special message to Congress on home rule for the District of Columbia, quote, "Our federal, state, and local governments rest on the principle of democratic representation. The people elect those who govern them," close quote. Accordingly, President Johnson underscored that self-government for the District of Columbia would not be an innovation, but rather simply mark a return to the bedrock principles of our republic. In particular, he cited Federalist Paper number 43, in which James Madison conceived that inhabitants of a nation's capital, quote, "will have had their voice in the election of the government which is to exercise authority over them, as a municipal legislature for local purposes derived from their own suffrages will of course be allowed them," close quote. In this vein, the 93rd Congress enacted and President Nixon signed into law the District of Columbia Self-Government and Government Reorganization Act, otherwise known as Home Rule. While this legislation expressly preserves the authority of Congress to review acts adopted by the D.C. City Council, the bill's text and legislative history also reveal a congressional intent to confer significant legislative authority in the District of Columbia over local matters. In particular, the, quote, "statement of purpose" included in the Home Rule Act of 1973 provides in part that it is the intent of Congress to, quote, "grant to the inhabitants of the District of Columbia powers of local self-government to modernize, reorganize, and otherwise improve the governmental structure of the District of Columbia, and to the greatest extent possible, consistent with the Constitution, constitutional mandate, relieve Congress of the burden of legislating upon essentially local district matters." Again, this is an employment ordinance. I think the people of the District of Columbia are well equipped to decide what protections employees within the District of Columbia shall have. Similarly, the Senate Committee on the District of Columbia report accompanying the bill provides that the District Council would be endowed with local legislative power. Now, this bill, the rationale behind it is to address a perceived loophole in the D.C.'s current anti-discrimination law that may leave employees vulnerable to discrimination on the basis of reproductive health decisions. The committee report, therefore, explains that Washington, D.C. simply sought to follow the legislative trend of states such as New York, Michigan, North Carolina, and others that have introduced legislation to ensure that their anti-employment discrimination framework are applicable to reproductive health decisions. Our democratic commitment to the principles of local self-government and the congressional intent evidenced by the Home Rule Act require that we approach a disapproval resolution with great caution and make every effort to respect the basic rights of D.C. citizens through their elected city councilors to enact legislation affecting D.C. affairs. Regrettably, in this instance, we're moving forward with a mock-up of a House Resolution 43 without even holding a hearing on an issue that has been under consideration in the D.C. City Council since May of 2014. Simply put, it is not the role of this Congress to presuppose the unconstitutionality of this legislation on the basis of vagueness. This is a local employment ordinance, and the good people of Washington, D.C., through their local representatives on the D.C. Council, have articulated a standard by which their employees should be protected, and that is an inherently local interest. With that, Mr. Chairman, I yield back, and in doing so, I urge my colleagues on both sides of the aisle to oppose this resolution, and I yield back the balance of my time. Thank you,
gentlemen. Now I recognize the gentleman from Michigan, Mr. Wahlberg, for 5 minutes.
I thank the chairman. I thank you for having this markup, this hearing. It is important that we address this. And I think it's been stated very clearly that this is very unusual for us to meet and take action relative to D.C. and their home rule. This isn't something we do all the time. I think we need to remember that. It's been stated that D.C., they want to rule themselves. I understand that. But we would not suffer states or local communities to simply say, we want to rule ourselves, and so we will do anything we want, regardless of how it violates the constitutional individual rights that are placed in the Constitution for specific purposes of freedom and liberty, within the constraints of making sure that we never violate anyone's inalienable rights. It's been stated that this isn't the decision about our moral government. Well, yes, it is. It's stating that those who have a moral premise, nay, a moral conviction, that isn't just traditional in the sense of an organization, but is heartfelt. It is a purpose of character and conviction. And if it goes against what this local home rule board says, it doesn't count. That's a moral statement. This is really not an issue of home rule. This is not an issue of abortion on demand. This is not an issue of a woman's right to choose. This is not just a continued effort to make sure that there's not discrimination in our workplaces. That's how it's being stated. But that's not the issue or the issues. You see, I believe, Mr. Chairman, this is a continued attack on religion and a person's First Amendment rights of freedom of belief if it goes against a small but vocal element. You see, as a pastor and a minister myself, I never wanted to discriminate against anyone coming to my church. In fact, I hoped that people would come to my church who disagreed with me, and I'd have an opportunity to offer them my beliefs for them to consider. I wanted to see their life changed if indeed they saw that as a necessity for them to change and move a perspective that I had. Otherwise, they were free to make their decisions. Mr. Chairman, I wonder what will be the position of my colleagues when an employee of Planned Parenthood comes to a conclusion that abortion isn't a good thing, and that employee of Planned Parenthood decides that they will speak out publicly against it, but remain under the employee of Planned Parenthood because that gives them a framework and a format. Will that be spoken of in defense of as strongly as I've heard my colleagues speak against this resolution tonight? Ideas have consequences. And it ought to be consequences that affect us equally and preserve the rights that are given to us by the Constitution. It is clearly taught by Jesus, the Christ himself, for those of us who believe him, and I understand and I accept the fact that those that don't. But he said, render to Caesar what's Caesar's and to God's what's God's. And I think that's an important consideration for us on this committee tonight, and how we deal with a responsibility we have we have constitutionally for the District of Columbia. Thank you, and I yield back.
Thank the gentleman. Does any other member wish to be heard on the resolution? The gentlewoman from New Jersey, Ms. Watson Coleman, is recognized.
Thank you very much, Mr. Chairman, for recognizing me. I've only been in Congress since January 6, 2015, and I've really experienced some very shocking and stunning votes and considerations and debates and concerns, but I don't think I've been offended by anything as much as I am about being here about this issue. This is not about a religious freedom for or against. This is not about equal opportunity for or against. This is about another opportunity to raise the issue of a woman's right to her privacy and to make the decisions regarding when, if, how, and under what circumstances she will conceive or not conceive. It is absurd and arrogant and ignorant that in 2015 we would be having these discussions. It's not about home rule, small government, large government. It's about the Republican Party's failure to come into the 21st century on issues that have to do with a woman's right to choose. And so the Jesus that I serve tells me that you should love your neighbor, you should feed the poor, you should take care of the child, you should be your brother's keeper. And I don't see our doing that when we put our budget bill. You put your budget bill together on the Republican side, and it chooses to reduce food stamps and access to subsidies that are created because we won't even in Congress take up a minimum wage bill. So I just need to be on the record. I don't have a flowery speech, but I tell you, I find this exercise, this waste of time, this waste of taxpayer money, holding this committee meeting for this reason to be unacceptable and very hurtful to me as a woman and as a legislator who was elected to come down here and to take care of serious business. Thank you for recognizing me. While I will be here, excuse me one second, sir, while I will be here for the vote, I will not sit here and listen to any more of this.
Would my colleague yield? Behind you.
Yes.
I thank you. I wanted to respond to Mr. Wahlberg. I respect his religious views. I respect his sense of scriptural context. But America was founded on the right of everyone to express their religious opinion and to practice their religion freely without the establishment of a religion. And I'm sure Mr. Wahlberg can respect the fact that there are others of us who come from religious traditions. You, Mr. Wahlberg, indicated you are yourself a minister. I studied for the ministry, for the Roman Catholic ministry. And I am steeped in the social justice doctrine of my church. But I certainly don't think that it is my job to propound the dogma of my church as a member of Congress. I think I have a responsibility to reflect the plurality and diversity of religious traditions as an elected representative of the people. That doesn't mean that I'm not informed by my values and my religious background, but I have to respect the fact that there are other points of view, and I have to somehow reconcile that. And I just wanted to say that to my friend because—
Would the gentleman yield?
I would. Well, actually,
Well,
it's up to Ms. Watson-Coleman to yield. But I'm done. I wanted to say that.
Would the gentlelady yield for just to respond to my colleague and friend?
I would urge my friend to yield.
I would remind colleagues, this has been very civil, and I appreciate that, but I would remind both members to address their comments to the chair and not directly to another member. It is the gentlewoman's time. She controls the time. Did you yield back?
No yield.
They said yes.
Okay.
I thank the gentlelady, and Mr. Chairman, I thank you for allowing me these comments in response to my colleague and friend. And I would concur. I've stated many times, while I will not wear my religion on my sleeve, I will not hide my faith. And I agree with you. We should allow a plurality to go on. My concern with what the D.C. Board has done, it is said to me as an employer, unless I'm a religious employer, and there's a debate there as well, it's said to me that I cannot live out my faith life and my principles as an employer that has a convictional level that makes a difference in even who speaks for my business. It's not that I want to discriminate, but as a religious individual, as a person of conviction, I want to make sure that my message comes through clearly. It's not to discriminate against anybody else. It's to say you can have your position, and I applaud you for the right and the opportunity to have that. But I want the same for myself and for others like me who share convictions that are strong, that want to love people and accept them for their differences. But I want to be accepted as well. So I hope that makes it clear. I do not want to squash you and your beliefs, but I don't want mine either. I yield back.
Thank the gentleman. The gentlewoman's time has expired. Does any other member wish to speak on the amendment? I believe the gentleman from Missouri, Mr. Clay, is now recognized for 5 minutes.
Oh, thank you, Mr. Chairman. I appreciate it. And you know, I'm kind of shocked that so-called conservatives on this committee, who are allegedly committed to limited government and removing mandates from our daily lives, refuse to apply that same standard of privacy and personal freedom when it comes to a woman's right to control her own body and make her own reproductive decisions without fear of retribution from her employer. It is simply inconsistent to say that you support individual freedom except for the women who happen to live in Washington, D.C. It is insulting to support this resolution that would enable employers in D.C. to intervene in women's most intimate, private health care decisions and then subject them to discrimination in the workplace. You know, we've just seen some of this play out in the states of Indiana and Arkansas. And as you saw, both states and the governors had to backtrack because they overreached. And so, you know, by disapproving the RHNDA, this Republican resolution would allow D.C. employers to fire employees for using birth control or in vitro fertilization or any other reproductive health care service that is contrary to a particular religious point of view. House Republicans would even allow employers to fire employees for the reproductive health decisions that their employee spouses and dependents make. So I ask my colleagues in the majority to be mindful that while employers are entitled to their religious beliefs, they cannot use those beliefs to discriminate against their employees based on their personal reproductive health care decisions. If you truly believe in personal liberty, then this misguided attempt to overturn a legitimately enacted local law is wrong. And I ask my colleagues to join me in opposing this repugnant resolution. And, Mr. Chairman, I will stop there and yield back.
Gentleman yields back. Does any other member wish to be heard? The gentlewoman Ms. Kelly from Illinois is now recognized for 5 minutes.
Thank you, Mr. Chair. My question is, where does this end? We hear time after time, as my colleague just said, the government is too big, Big Brother's watching, government is too intrusive. Overturning this is certainly intrusive. So it seems to me that we use intrusiveness as it's convenient. I associate myself with what my prior Democratic colleagues have said, but this is another example of women being second-class citizens. Overturning this is penalizing women and their families. We talk about religious freedom, but it's only free if you think like the majority, whatever that happens to be. So much hatred and discrimination in the name of the Lord. Slavery, lynching, the Holocaust, Selma, Japanese internment. I can go on and on and on. The residents of D.C. voted these reps into office. And what is the point of them having a vote if we are not respecting their choices and what they've decided for D.C.? I'd like to yield the rest of my time to Congresswoman Eleanor Norton Holmes.
I thank the gentlewoman for yielding. I'd simply like to clarify, since ministerial exception has been raised here on my side and on the other side, that the ministerial exception means that a religious organization can hire or fire a minister for anyone at any time for any reason. And a religious organization can hire or fire any employee for any reason, including a janitor, because it is a religious organization. As to the example that was raised about Planned Parenthood, that suppose somebody spoke out against abortion, the employee must be willing to carry out the mission of the organization. So if someone, and that goes for all organizations, this is about conduct, not belief. If you get hired by an organization that is not in tune with your own belief, it is with the understanding that you must carry out the mission of that organization. If you do not, you can be fired. I hope we do not get conduct and belief confused. And I thank the gentlelady for yielding.
Does the gentlewoman yield back?
I yield back.
Gentlewoman yields back. Does any other member wish to speak on the resolution? Gentleman from North Carolina, Mr. Meadows, is now recognized for 5 minutes.
Thank you, Mr. Chairman. And I just want to acknowledge the civil debate that's been going on here, and I think it's a testimony of our desire to make sure that the rights of all individuals are upheld. I would like to point out that the delegate, as she so eloquently put it just now with a ministerial exception, that particular language is really not in the bill. It's not in the law, and it's very clear that if indeed that the intent is to give broad ministerial exceptions, then certainly we can have a whole lot more to talk about, and the delegate knows that I'm anxiously trying to find a way that we can avoid this, because certainly I agree with the chairman. I would prefer not to be here today debating this disapproval resolution. Yet today the rights of many in our nation's capital here in the District of Columbia are being challenged. Americans expect their local, state, and federal governments to respect their constitutional rights, and yet the Reproductive Health Non-Discrimination Act, or RONDA, claims that it will prevent discrimination within the district. However, this bill does exactly the opposite. It discriminates against religious and politically affiliated organizations within D.C. As already has been stated, RONDA would prevent organizations within the district from making employment decisions that align with their consciences and further that mission of their organizations. Now, I know the delegate was indicating that that's not the case, but certainly the law that is before us and that has been transmitted to us today is at best ambiguous in those areas. The Religious Freedom and Restoration Act of 1993 clearly stated that the government shall not substantially burden a person's exercise of religion. However, provides an exception that a government may substantially burden one's exercise of religion, provided that it is the least restrictive means of furthering that compelling governmental interest. I find it hard to believe that this is the district's most burdensome bill that would qualify under those least restrictive means. The easiest solution to this problem would be for the D.C. Council to provide an exemption for these groups. In the Supreme Court decision, Hosanna Tabor versus the EEOC, it ruled on the use of the ministerial exception for certain circumstances, but explained, quote, we are reluctant, these were the justices, we are reluctant to adopt a rigid formula for deciding when an employee qualifies as a minister. I agree that a rigid formula could indeed have its own set of pitfalls and be too restrictive or too broad. However, in the case of Rhonda, I believe that there are strong constitutional reasons for extending the spirit of the ministerial exception to cover these organizations that would be negatively affected by this bill. You know, I invite the D.C. Council to introduce legislation right away that would do that, that would restrict it. I join the chairman in saying that, you know, I wish this markup had not occurred. But at this point, I feel like we have no choice but to stand up for the constitutional freedoms within the district and outside. So, Mr. Chairman, I thank you for holding this markup. Sadly, some have viewed this bill as a message that says that many in the Catholic faith, Catholic churches, Catholic schools are only welcome in D.C. if they keep their religious beliefs to themselves. And that's not the case. I don't think that's what either side wants to convey. But it's important that we clarify this language and make sure that we're not trampling on the rights of others at the expense of trying to uphold some other home rule and protect government.
Will the gentleman yield? You have time.
Surely.
So I would like to yield just to offer the clarification you desire. And I'm quoting from the D.C. Human Rights Act of 1977. Nothing in this chapter shall be construed to bar any religious or political organization or any organization operated for charitable or educational purposes which is authorized, supervised, or controlled by or in connection with a religious or political organization from limiting employment or admission to or giving preference to persons of the same religion or political persuasion as is calculated by the organization to promote the religious or political principles for which it is established and maintained. This goes even beyond the constitutional basis for the ministerial exception.
Thank the gentleman. The gentleman's time has expired. Now recognize the gentlewoman from Michigan, Ms. Lawrence, for 5 minutes.
Thank you, Mr. Chairman. I have stated here before that one of the previous jobs I had for the federal government was an EEO investigator. And I've sat through many cases where there were issues of employees feeling like because of their religion they were being discriminated against. People who wanted to work, needed to work to provide for their families. And then you add on top of that, as a woman, the fact that I have a choice to make a decision that's right for me, with my God, right for me, for my personal health, right for me with the decision between my spouse and I or the father of the child, will even be a consideration for my employment. Right now, it saddens me to be a member of Congress. I listen to those cases as an EO investigator where people say that my faith or my belief is something that I feel that I'm being treated differently in my workplace, or I'm being held back in jobs because I am not the normal religious person, or I'm different. And I would use the law, and I would use Title VII of the Civil Rights Law, and I would investigate and interview and educate about how important it is, how legally it's responsible for an employer to not discriminate against a person because of their religion. I find it difficult to believe that what we're talking about does not insert the pure intent of Title VII. I have the right, and I work for the federal government, and I know I work next to people of all different kinds of beliefs. It did not impact their ability to work. It did not change their character. It was their faith and their belief, and they were hired to do a job. And at no time did we say that you cannot sit at this desk or use this computer because who you call your God. It is, I have repeatedly told individuals, because I'm very much pro-choice, I said, you know why I'm so passionate to be pro-choice? So you as a woman will have the choice to be pro-life if you choose. You have the choice to make a decision if it's between your health and giving birth, that you can make that decision. That if your husband and yourself have to look each other in the eye and make a decision, or you as a single woman by yourself, or a woman who's been a victim of incest or rape, can sit there and make a decision about her own body. I'm passionate about that. And why we keep bringing this discussion forward again and again, I want you to have your right to have the faith that you feel is right for you, to call on the God that you want. Also want myself and other women to have the choice to do what's right when it comes to their reproductive rights. I don't want to tell you to have an abortion. I don't want to tell you to have your child. I want you to have the choice as a woman to make that decision. And in America, that is what we built this country on, religious freedom. When the boats were coming from all over the world to set their foot on this amazing land we call the United States, is because the majority of them wanted religious freedom. And they could open a business, they can go work in a factory next to someone who was totally different to them, and we wave the flag and say, we're America. We're America because every man and every woman is free. But then we consistently bring laws and these policies forward it's the slippery slope of moving back to a period where you are discriminated against or treated differently because I have the right to do it because I'm a member of Congress. This is a sad day for me as well, and we should not do this to us as Americans. Thank you.
Thank the gentlewoman. Does any other member wish to be heard on the resolution? Gentlewoman from New Mexico, Ms. Lujan Grisham, is now recognized for 5 minutes.
Thank you, Mr. Chairman. I also am saddened that we're here today to advance a resolution that invalidates the District of Columbia's law to protect its citizens from discrimination. Supporters of the resolution argue that employers should have the right to fire employees that they disagree with, whether or not that disagreement is in any way related to their job performance. I think most Americans would say that employers have no business interfering with personal and private decisions that employees make with their family and their health care provider. Women who use contraception or try to conceive through in vitro fertilization should have the same employment opportunities as anybody else, including men. At its core, this is an economic fairness issue. Employees, male or female, should be judged on their work performance, not their private medical decisions. Healthcare decisions should be made by patients in consultation with their healthcare providers and their families. There is no appropriate role for an employer or for members of this committee in that process. I urge my colleagues to oppose this resolution, and I yield back.
Thank the gentlewoman. Does any other member wish to be heard on the resolution? Any other member? Now, in consultation with the ranking member, is the intention of the chair to make sure that all members have an opportunity to vote on this important resolution. And so, therefore, we are going to go into recess, in which time we will reconvene after the vote no sooner than 7:15, at which time we intend to vote on the resolution.
Mr. Chairman, I have an amendment at the desk. Is that in order
But
now?
I guess before we go to the resolution, the gentlewoman, or going to the recess, the gentlewoman, Ms. Maloney?
Yeah, I have an amendment at the desk.
As mentioned earlier, the expedited procedures for the Home Rule Act provide that the joint resolution is unamendable on the floor and thus unamendable in the committee. Your amendment is not in order. We cannot entertain any amendments to this resolution.
But I feel strongly about it. I'd like to go on the record that I have an amendment that I believe should be put in order, and I think it's an important amendment. If you want to rule it out of order, it's up to you, but I'd like to put it forward.
We, unfortunately, we checked with the parliamentarian prior to this actual markup, and under the rules, we are not allowed to entertain an amendment.
Okay, I yield back.
Thank the gentlewoman. So as I was
Mr. Chairman, I also have an amendment at the table.
The gentlewoman as was mentioned, the expedited procedures for the Home Rule Act provide that the joint resolution is unamendable on the floor and thus unamendable in committee. We simply cannot, under the rules, entertain any amendments.
Mr. Chairman, I feel very strongly that my amendment to prevent discrimination against employees for using IVF procedures is germane to this and should be ruled into order.
I thank the gentlewoman, but the amendment is not in order. I simply cannot rule any amendments in order.
Thank you, Mr. Chairman.
Mr. Chairman,
Gentlewoman from the District of Columbia.
Mr. Chairman, if she has an amendment that's out of order, we haven't even heard it. Couldn't she be allowed to at least tell us what her amendment would be?
It's according, what I'm advised, it's according to the Home Rule Act. I'm simply unable to even entertain the amendment, in any amendment.
You know, Mr. Chairman, it is routine for members to be able to offer amendments and simply have to withdraw them because they're out of order or for some other reason. Even the mayor and the city council haven't been able to defend their law. So for this member not to be able to say what our amendment would be leaves me wondering, well, what would it be? If it's out of order, then it's out of order, and it won't be upheld.
I think the gentlewoman, all amendments are out of order. I'm happy to recognize Ms. Duckworth for 5 minutes if she would like to speak on the resolution overall.
And will the gentlelady yield?
The gentlewoman doesn't control the time.
Well,
Does the gentlewoman, Ms. Duckworth, do you care to be recognized to speak?
Yes, I would, Mr. Chairman.
Gentlewoman is recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Chairman, what I had wanted to offer was an amendment to make it clear that no one in the District of Columbia should have to fear facing punishment from their boss for trying to start or expand their family. My amendment would have prohibited an employer from discriminating against an employee who uses infertility treatments. I recently experienced the extreme joy of becoming a mother for the first time. This miracle was not possible without the aid of in vitro fertilization, something that I was told, like my pregnancy likely could not have happened without in vitro due to the excess radiation exposure I received during treatment for my combat-related amputations. I feel very strongly that it is heartbreaking to know that women in our country could be fired simply for using in vitro. For example, Emily Hertz, a language arts teacher at Catholic schools in Indiana, was fired after school authorities discovered that she and her husband used in vitro to try to start a family. They sought IVF treatments after learning that she suffered from a medical condition that caused infertility. She was told that the procedure was contrary to church teachings, and as a result, her teaching contract would not be renewed. Last December, a jury sided with her, awarding her damages in the case. Those seeking to start a family should not have to choose between getting the fertility treatments they need or keeping their jobs. This is not about religious freedom. It is about the freedom to make an incredibly personal and significant decision without having to consult your employer. Employees like Emily Hertz should be judged at work based on their job performance and not on private decisions they make with their families and doctors. That's exactly what the D.C. Council intended to ensure in passing this resolution to protect the women in D.C. from facing the same discrimination that Ms. Hurst did. I urge all members to support this resolution. I urge all members to oppose this attempt by the majority to limit the rights of the people of the District of Columbia, because in this day and age, the last thing we should be doing is punishing couples who are having difficulty starting a family. I yield the remainder of my time to Ms. Maloney.
The gentlelady yield me some of her time?
I will remain the remainder of my time to you. Thank you.
Oh, I thank the gentlelady for allowing me to speak. I have an amendment at the desk which I think should be put in order. But in any event, I would like to put my amendment forward because I feel strongly about it. And my amendment would make it clear that an employer in Washington, D.C. may not fire any employee on the grounds that the employee or the spouse or the dependent or any employee used a FDA-approved method of birth control. Researchers and staff at the FDA have a rigorous process to determine the efficacies of drugs on the market. This is certainly true for methods of birth control, and my amendment makes it clear that the use of these FDA-approved drugs, many of which you can get over the counter, is not grounds to fire a worker. This means that an employee couldn't be fired because his spouse or her spouse used some form of birth control. Or any employee couldn't be fired because their daughter used in vitro fertilization. This is just common sense and fairness. And there is good news, I might add, in the employment sector. Jobs were added for the past 60 months, and unemployment rates have gone down to 5.5%. We shouldn't threaten this progress with stories like this of women in Indiana, Florida, Montana, New York, and Ohio who were fired because of their personal reproductive choices. What are we coming to in this country? In several of these cases, women were fired for having the joy of carrying a child. And it's breathtaking and heartless to fire these women just because, and absolutely when they most need medical care and money to care for a growing family, just because these women are having a child. And I support everyone's constitutional right to freedom of religion. That is a major part of our values in this country. But these beliefs should not be used to discriminate against another person, against employees, and to fire them based on the medical choices that are legal, that they have decided to make. And I understand the chairman has made it very clear that he will not accept these amendments. But I want to continue to urge the chairman and the members of this committee to consider the ways his resolution would threaten the jobs and economic security of hardworking D.C. residents. And I, for one, stand with the workers of our nation's capital in protecting their jobs and protecting their health choices. This is an extremely disturbing decision and movement. And I yield back to the gentlelady who yielded me the time. Thank you, and thank you for. I wish I had the opportunity to vote for your amendment, Ms. Duckworth. I think it's a really important one, and I believe it should be put in order.
I thank the gentlelady. I thank the gentlelady, and I also would like to thank the chairman for recognizing us to speak. Thank you.
Thank you. Of course. Again, just to understand that the spirit of what this committee does is an important one, and I appreciate the dialogue. We're simply voting yes or no on the resolution before us. The reason that I think this is there, and it's an important one, is that we're not here to amend D.C. laws. It's yes or no. Do we disapprove or do we not disapprove? But to go back and amend that ourselves, I think would also would be a step too far. But we do have the ability and the opportunity to bring up a bill such as we have and do a resolution of disapproval. We'll now recognize the gentleman from Georgia, Mr. Heiss, for 5 minutes.
Thank you, Mr. Chairman, and I appreciate your comments of bringing us back to what we're really dealing with here, and that is the issue from the City Council. I think in a broader perspective, so many Americans these days across the board are not only recognizing but deeply concerned with the multiple attacks against our constitutional rights, not the least of which is our First Amendment. And when we come right down to this issue, the bottom line, to me at least, is that the government simply cannot require individuals or organizations to violate and or forsake their beliefs and then claim to support the First Amendment. I'm really struggling with how we can come to the point of allowing our government to force people to participate in actions that to them are offensive. I just can't wrap my mind around this. Why we would allow and say it's okay for our government to force people to participate in activities that they believe are wrong in order to stay in business. No government should be allowed to tell anyone that they have to choose between their faith or their job. And it just, to me, is wrong for us to look at it any other way than to acknowledge that exercising the First Amendment is not a crime. And the Constitution, at the end of the day, makes clear that our government is prohibited from limiting or punishing people for their religious expression. So I think for us to come to the conclusion that respecting religious liberties, when it can be reasonably accommodated, is both common sense and constitutional. And in this case, before us this evening, I see no reason whatsoever not to accommodate individuals who have deeply held values and beliefs. And with that, I'd like to yield the remainder of my time to the gentleman from Oklahoma, Mr. Russell. Thank you.
And thank you, Mr. Chairman, and thank you, Mr. Heiss. I appreciate that. Mr. Chairman, it was asked to what end would we see these things carried out, and in the ensuing civil discourse that we've had, it was suggested that enslavement, Holocaust, Japanese internment, and civil rights were somehow laid at the feet of our party. I would like, having a master's degree in history, to point out that enslavement was ended by Abraham Lincoln, a Republican, and abolitionists were also Republicans. The Holocaust, the Jewish immigration quotas and restrictions that were imposed by our nation was done under a Democratic executive with a democratically controlled Congress. Japanese internment laws were put into place by a democratically controlled Congress and a Democratic executive. Jim Crow laws, like my state in Oklahoma, they were done at the time by Democratic legislatures that intruded on those civil rights. And while I understand that few today, to include our distinguished members on both sides of the aisle here, would suggest that any of these policies were good, I do think it's important, Mr. Chairman, to point out that historically they do not belong to the Republican Party. It was also suggested that the choice and the passions for women's reproductive rights is of paramount importance, and we've certainly heard that and appreciate that today. I want unborn children to also have that choice on the right to live. Until they have that voice, I will make no apology for being theirs. Thank you, Mr. Chairman, and I yield back to my colleague.
Thank you. The gentleman, Mr. Heiss, yields back. Does any other member wish to be heard on the resolution? At this time, the committee will stand in recess. It's the intention of the committee to reconvene at 7:15, no sooner than 7:15, after the conclusion of a vote on the floor, which will happen at any moment, and we intend to have a vote at that time.
Question?
Committee stands in recess.
Question, Mr. Chairman. Do you anticipate a recorded vote or a voice vote?
I'm sure it will be recorded.